Ms. Ruhtenberg, are you ready?
Yes, thank you. May it please the court, counsel? Good afternoon. My name is Maria Ruhtenberg. I represent Mr. Boyer here today. Without conceding our argument in our brief, point one, in light of this court's decision in State v. Gross, today I plan to focus on the second brief point in my brief, which is the due process argument. I think a timeline of the events surrounding the order for room and board for the jail fees is instructive. On September 24th of 2018, the defendant was sentenced to prison. On 4 days later, September 28th, he was served with a claim for room and board for his stay at the Mills County Jail for $4,680 for his stay ending on that day. That notice, or that claim, I should say, told the defendant the amount due immediately upon his release from incarceration, and if it wasn't paid immediately, it would be filed with the court and collections would follow. There was no notice of any kind of right to respond or right for hearing in that claim. About a week later, that claim was filed with the district court, even though the defendant was actually still incarcerated. He just wasn't incarcerated in Mills County. He had been sent to prison. On the same day, the judge approved the claim, entering judgment for that amount, stating that the defendant had 20 days if he wanted to have a hearing about it. That same day, the order was mailed to the defendant's address in Texas, despite the fact the defendant was in prison in Iowa. On October 26th, 21 days later, the judgment was sent to collections.
No copy was mailed to him in prison?
Not until November 14th. There's an entry in the docket that the order was returned. The letter was returned undeliverable in the Texas, at the Texas address, and the notation says that it was resent to a current address. I don't know. It doesn't say what address that was.
Was the attorney of record released at the time of sentencing?
I'm sorry?
Was the attorney of record for the defendant released at the time of sentencing?
He was released, but he did a motion to withdraw, I believe, if memory serves, it was after the notice of appeal was filed.
So when the claim was filed and approved by the court with a 20-day notice for hearing, was there still an attorney of record who would have gotten that notice?
Yes. I think he was still on the record, but he didn't respond, and there's no indication of anything happening with that.
When does your client say is the first time he received a copy of this order, the October 5, 2018 order?
I don't know that I've ever asked him that question or if he knows. All I know is from what's on the docket that it was resent in November, in the middle of November, which was obviously too late for anything to happen. There was problems with this, many problems with this, and not the least of which is the judgment cannot be entered against the prisoner without the appointment of a guardian ad litem. Even though he had an attorney of record, if there is no guardian ad litem or no representation in a civil judgment, that judgment is considered void. It's also void because there was no due process, and there was lack of notice that he had this hearing. Clearly he didn't have notice of it at all, so the court would lack jurisdiction, personal jurisdiction over him, rendering that judgment void. The lack of due process in civil, I'm not a civil lawyer, but I know enough to know that there's, a petition filed, an original notice, tells the defendant how many days he or she has to respond. If it's not small claims, there's discovery, there's a jury trial. And in this case, none of those things happened.
All right, but if we actually get to the merits, it seems like a pretty straightforward computation, 78 days times $60 per day. My experience is clients usually know how long they've been incarcerated, and I assume he doesn't dispute the 78 days in jail part.
I don't know if he would dispute that. I think there are other issues that could possibly be raised. It could be a constitutional issue. There could be due process issues. There could be other defenses, how they come to the $60. I mean, those are just things that I can think of. Maybe a person would want a hearing or a trial to delve into. So I don't know what kind of defenses or challenges he may make to the claim itself.
Let me ask you this question based on the chronology. I'm looking at the notice of appeal that was filed pro se, and it says, notice is hereby given that Travis Boyer appeals from the final judgment and sentence entered in these matters on the 24th day of September. So the notice of appeal mentions the orders of the 24th day of September, but the order that had the 20 days, etc., was October 5th. So I just asked this question, do we have jurisdiction? I mean,
Well,
he's appealed the final judgment entered on the 24th.
I believe the court does have jurisdiction. I mean, it's a criminal case. He's not as sophisticated as ordinarily an attorney would mention all adverse rulings that they appeal from. I think in pro se filings usually give them a little leeway on that, and in treating this as we have a traditional criminal case, we will raise issues adverse.
Wasn't there some leeway given to him on actually the jail received? He mailed it as best as an incarcerated individual can, and apparently the facility didn't get it out the door. And so the court did give him that leeway that he placed it there. But leeway as to the content of it for a pro se person, tell me your authority for that.
I don't have any specific case that comes to mind, but I just know that from experience, I can't name a case, but I know I have read cases from this court that have, in other filings, been a little bit generous with defendants in their pro se filings.
I think that's true with procedure, but the actual content, the really substantive matter, I agree with you. I've seen some of those happen before, but my recollection and my inclination is the opposite of yours, that it's not a lot of leeway.
Okay. Like I said, I don't have a case for you right now. I can supplement if the court would like.
Our cases say that if you don't appeal within 30 days or are granted a delayed appeal, this court has no jurisdiction. The order entered by this court, and I think I signed it, but the order entered by this court says that we're going to allow you a late appeal on the September 24th, 2018 order, not on the October order or a November order. So how do we manufacture jurisdiction when there is, you're arguing an order October 5th, and he appealed something that happened September 24th, and that's what we granted. We didn't grant any other order. We didn't say or any other orders in hearing therein. That was an order filed December 7th by this court. So I really have a real problem of how we have jurisdiction to discuss anything other than that September 24th order.
Well, I know, the defendant wouldn't have known about the order at the time, about the claim for the attorney's fees. Or up until, this was all...
That even makes it worse because the only thing he's appealing is the September 24th order. He wouldn't have known to appeal the restitution order because the restitution order didn't get to him because he filed his notice on November 2nd. So I can see no intent by this defendant to appeal that October 5th order.
Well, up until this court's decision in Gross, we had treated these as basically restitution cases because that's how they had always been treated before. And our filings, this case was submitted prior to the Gross decision. And when we do appeals, we don't necessarily only raise the issues that the defendant is aware of or knows about or wants to appeal.
But it does seem, that what he was trying to appeal was the original sentence, not this restitution order, whether it was a civil restitution order or not, right? His notice of appeal, he wasn't even, according to you, aware of the civil restitution order. His notice of appeal references the actual the date of the actual criminal sentence, not this civil restitution order. So how can we jump ahead and infer an intent to appeal the civil restitution order?
Well, I suppose the only thing I can really say without it wasn't raised before today, so I haven't done the research on this. Excuse me. I guess the best I can come up with at this point is to ask the court some leeway with a pro se filing that he intended to appeal this case, and he wasn't aware of this. It's an issue in the case that we raised. If there is some authority out there, I would be happy to supplement if the court would give me leeway, but I wasn't prepared for that today.
But if this really is a civil order entered without jurisdiction in the district court, he could raise that at any time in a civil action, rather than appealing that order, because civil judgments, it's my understanding, civil judgments entered without jurisdiction are void, and they're not enforceable.
Well,
so, I mean, I don't know if you're guys without a remedy. I don't know if there's a time limit on that, but I do know that I don't see anything in the record to appeal this order. And if someone tries to collect this order from him, you may be able to bring an action voiding the judgment, because if it truly is a civil judgment and it truly was obtained without jurisdiction, it's void.
Also, the only thing I would say is that a void judgment can be attacked at any time. It is similar to a illegal sentence that can be attacked at any time. So, and I have a case for that.
I agree with that, but isn't that his remedy at this point, because he didn't appeal the right order, that he needs to bring an action to void the judgment? That
could possibly be a remedy for him, but this was done in the criminal case, so it's a hybrid of.
Can we say in gross it's really a civil judgment? It's not a criminal judgment?
It is, and you did. Again, I'm not conceding that, because we did raise it, and we still believe that if it's filed in a criminal case and has all the markings of a criminal restitution, that they're just trying to get around some things by calling it a civil judgment. But the procedure in this case is so unlike if it's a civil judgment filed in a criminal case. It's a hybrid, really, because there's no procedure to have a hearing or to attack it or to address these issues.
I want to go back to that comment you made. Maybe you're just asking for leeway for pro se filing. Isn't that an incredibly slippery slope? I mean, a smart lawyer would tell his or her client, you know what, we've missed a deadline, so don't hire me. Just go file it. Isn't that going to set a precedence that will get breaks if you don't have a lawyer? Is that the message we would want to send on an argument like that?
Well, he did file it pro se, and the court did allow him to proceed on the late appeal. So I think,
that's procedure. I guess I'm more concerned with the fact that a different order was mentioned that was being appealed, which I think is extremely substantive.
I don't know the answer to that question, if it's a slippery slope or not. I don't see that. I mean, here he had an attorney. I think his attorney probably should have filed the appeal for him, but I don't know the answer to your question. If other lawyers would
any
do
authority for giving leeway on substantive issues to pro se people?
Like I said, I wasn't prepared to argue that today, so I don't have an authority case for you off the top of my head. I apologize. Thank you.
Thank you very much. Ms. Trout?
May it please the court, counsel? There are several flaws in the defendant's argument which would necessitate this court affirming the district court and the order for the civil judgment. First and foremost, this claim...
Does the state concede this is a civil judgment?
Yes, Your Honor.
How can a civil judgment be entered against a prisoner without a guardian ad litem under Rule 1.211?
Your Honor, the case law that talks, that interprets that goes specifically or states that the rule is intended to bring before the court a vicarious presence of one or more, or one who for some reason is unable to attend a civil trial or present a defense. What we're talking about in this instance is not a civil trial. What we're talking about is a civil judgment, which this court has found is appropriate and can be imposed or ordered as a result of Iowa Code Section 356.7.
And then in Gross, we had a whole list of horribles and problems, and this was one of the horribles.
Yes. Yes, Your Honor, that's true. That's true. But we're kind of in uncharted waters if you think that 356.7 was first discussed in Abramson, and both in Abramson and subsequently in Gross, the court talked about the kind of two lines of attack for the county sheriff to recoup those room and board fees. One is through an order of restitution, and one is through the civil judgment, which was the option that occurred in this case. So when we talk about that civil judgment, I think that one of the reasons why the court, there's a flaw in the defendant's argument is, first of all, the defendant didn't appeal from that October 5th ruling, so the court lacks jurisdiction. Second of all, Your Honor, the civil procedure rule has been brought up for the first time in argument. It was brought up the first time in the notice of authorities. It wasn't raised below. And
Nothing was raised below because they never had a hearing.
Well, they didn't have a hearing because the defendant didn't ask for it. And that brings me to my third point, which is the defendant was given all the process that he was due in this instance.
Is post-judgment process due process in a civil case?
Your Honor, what we're talking about is, well, in this instance, yes.
What authority do you have for that?
Well, Your Honor, it's a situation in which the defendant was given notice, personal notice that the court intended, or excuse me, that the sheriff intended to recoup his fees, which he is authorized to do under 356.7.
But that doesn't tell me anything about the hearing. He needs to have notice of October 5.
Right. And then subsequently, the notice or the ruling was filed with EDMS on October 5th. At that time, the defendant was still represented by trial counsel. So we believe that, and counsel didn't withdraw until November 13th.
Trial counsel was authorized to represent him.
No, I'm not saying that, Your Honor. I'm not saying that he was authorized, but what I'm saying is that we can presume that if the court provided notice to counsel, that the defendant who was still represented by that counsel was also given notice. And in that notice, the court allowed him to seek a hearing within 15 days, and that didn't happen.
This sort of smells like the old confession of judgments that most courts said didn't comport with due process, where they gave post-judgment hearings after the civil judgment was entered.
Well, Your Honor,
that really bothers me because it is a civil judgment, and I think you got to comply with due process for a civil judgment and the rules regarding civil judgment.
Well, Your Honor, I think that what helps us here is if we're talking about, and I know we talk in Jenkins about post deprivation, but let's look at the pre and post deprivation cases of Walters versus Grossheim, where we have these judgments, and then when a person is incarcerated at the DOC, they're provided notice that this is how much they owe in restitution, and if they have an objection, then they have to lodge that objection. I don't think that this is any different than that.
Is it really even, here's my question. I mean, there's sort of an assumption that this is a post deprivation. I mean, as I read the court's order, it doesn't become a judgment until the 20 days have passed.
Well, that's true, Your Honor. I mean, it harkens a little bit to Albright as to those temporary versus final orders, and you're right. I mean, the defendant hasn't been, no monies have been taken out of his account at this point.
Nor can they be. There's
Correct.
Nothing effective. This isn't like, there are the cases we read in law school about the attachment. They run out and grab somebody's property, and then they have to run in and get a hearing. Nobody can take anything from him until 20 days have passed, right?
That is true, Your Honor. And at this point, when we look at the civil cases, I mean, the defendant has to do something in order for to protect his rights. He does have rights. The court informed him that he had the rights, and yet he did nothing. This is not a situation where the defendant was completely denied any notice and he was denied an opportunity to be heard. Quite the contrary exists in this case and on this record. And unless there are any other questions,
Well, I guess I have another question. I mean, this person was convicted of a pretty serious crime. He was not going back to Texas. So why did they send the order to Texas instead of to Oakdale or wherever?
well, Your Honor, I don't have the answer for that question. However, I do know that in State v. Gross, the exact same thing happened, where the notice was sent to the home address or whatever.
Right, and we raised again, like Justice Wiggins was saying, we reserved a whole lot of issues, and that certainly, due process was certainly one of them, right?
Yes, that's true, Your Honor. And how, by what mechanism the court provided that access, perhaps the address wasn't updated with the court system. That might be the explanation. I don't know on this record. It's a very limited record. But as the court found in Gross, I mean, he still wanted to appeal, and he did at least try and appeal that other order. So we do have some notice. But whatever the outcome, we urge this court to provide either a protocol or some guidance for the practitioners and for the district courts. As I'm sure you are aware, the restitution and civil judgment issues have become quite numerous as of late. And I think that this is a call for the court to provide the district courts with a clear guideline as to what and how these matters should proceed.
But if we have no jurisdiction, we won't get there, will we?
Well, that's true. That is true, Your Honors. But perhaps, as you had left open some issues in Gross, that might devolve into additional cases which would provide some guidance on the law. But for these reasons, we ask that the court affirm.
Before you step away, if you're asking us to provide protocol and guidance, what protocol would you urge us to adopt?
At the very least, to have the defendant object in some way, shape, or form to that district court order.
Having the rules of civil procedure apply and just have them served. That's a clear rule.
Well, Your Honor, that may be true, but I think that we have to, this is, in much like many restitution cases, this is a bit of a hybrid between what we have in a criminal context, where the defendant does have a Sixth Amendment right to counsel, as opposed to what we have termed a civil judgment.
On a civil judgment, he doesn't have a right to counsel, I understand. Is that your position?
Well, I think that under the facts and circumstances of this case, this is not a situation in a perfect world, and I've said this in my brief, and we said it in Gross. In a perfect world, this would have been filed as a civil claim. However, the statute allows the county sheriff to simply file that request.
Is this a criminal matter that we're dealing with?
At this point, no.
Right, so he's not entitled to counsel in a civil matter.
Right. But Your Honor, he's not entitled to a Sixth Amendment right to counsel. I do recognize that the rule of civil procedure does exist, but I would also, we would caution the court to apply that rule of civil procedure to this particular set of circumstances, because what we have, again, is a statutorily authorized option for the county sheriff to seek these room and board reimbursements, and that one of the means by which they can do that is a civil judgment.
But the rule of civil procedures are there because when you're in prison, I can mail a letter I want, but it's not going to go to that prisoner until it goes through security or whatever else. And that's why, and when you serve a prisoner, you don't serve the prisoner, you serve the warden, the way the rules of civil procedure work. So the rules are designed to protect that prisoner, to make sure that prisoner gets notice. So I don't know how mailing it to the prison or wherever he is going to get him something within a timely manner by the time it goes through the security and whatever else it has to go through, the prison mail system. So it seems to me if this is a civil matter and you want to get a civil judgment and you're in prison, the safeguards set up by our rules need to be enforced.
Well, I disagree with that, Your Honor, because I think that when we look at the other cases that have involved civil cases in which a criminal defendant or an incarcerated individual has been named in a civil suit, there have been opportunities for those particular inmates to either appear or to, in fact, transfer was made in one instance where the defendant could either appear personally. That option was in all likelihood available to this defendant had he lodged any type of objection. And I would also remind the court that given the fact that this court, in granting the delayed appeal, also took that into consideration. There was no option for this district court to allow the defendant to appear because the defendant didn't lodge any type of an objection.
But by the time he got notice, the time to lodge the objection was gone.
Right, Your Honor. That's
so
true.
There was a judgment against him by the time he got notice.
That's true, Your Honor, but it wouldn't prevent a defendant who, in fact, in this instance, was quite prolific and had represented or had filed many actions on himself. Simply because the timeline has expired doesn't mean that any number of defendants wouldn't still seek to petition a district court for some type of relief, which we believe the defendant could do.
I have a very practical question, or maybe you don't know the answer to this, but in my experience with EDMS, hard letters are mailed to people at times, but we're always shooting stuff off through EDMS. What does the docket show? Does it show that the prison was getting notices out to this guy in addition to a hard letter that was returned from Texas?
Your Honor, I don't recall. The only thing I know is that there was notice provided via it was filed via EDMS, and what I am able to view, I cannot necessarily show exactly, or I can't tell exactly to whom everything was sent. But
and the attorney was still of record at all this time we're talking about.
November 13th is the day on which the attorney moved to withdraw. Yes. So, and if I believe opposing counsel said that the letter was returned, I have nothing to dispute that. But at the time, while this was pending, the defendant still had counsel and presumably was still had access to or information from via EDMS. But for these reasons, we ask that the district court that the district court's order be affirmed.
Thank you very much. Is there any rebuttal? I'm sorry. The case of State of Iowa versus Boyer is now considered submitted. You may adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.